Now, the Supreme Court heard oral arguments on March 18, 2024. We start with the arguments for the petitioner, the NRA.
Government officials are free to urge people not to support political groups they oppose. What they cannot do is use their regulatory might to add "or else" to that request. Respondent Vullo did just that. Not content to rely on the force of her ideas, she abused the coercive power of her office. In February 2018, she told Lloyd's, the insurance underwriter, that she'd go easy on its unrelated insurance violations if it aided her campaign to weaken the NRA by halting all business with the group. Lloyd's agreed.
When does urging someone become coercion? Well, as Mr. Cole, attorney for the NRA, mentioned, when the request comes with an "or else." For example, it was one thing for Ms. Vullo to suggest that Lloyd's might want to stop doing business with the NRA, but the promise to go easy if they complied is also a threat to go hard against them if they don't. This is not the only claim that the NRA made.
6 weeks later, she issued guidance letters and a press release directing the thousands of banks and insurance companies that she directly oversees to cut off their ties with the NRA, not because of any alleged illegality, but because they promote guns.
At one point, Mr. Ketiel, attorney for Ms. Vullo, suggested that these guidance letters were nothing special since the NRA had admitted to selling insurance that violated state law. However, Ms. Vullo did not issue guidance letters only to insurance companies, but to banks and other financial institutions as well. Now, if these letters were to punish the NRA for their insurance program, why encourage banks to stop doing business with them? Now, while these guidance letters did not specifically say, "do this or else," remember, DFS does regulate them. Just as Ms. Vullo could make life easy or hard for Lloyd's, she could for any company regulated by her agency. Now, Ms. Vullo was not working on this alone.
In the accompanying press release, Vullo's boss and co-defendant, Governor Andrew Cuomo, said he directed Vullo to issue the guidance because doing business with the NRA, quote, "sends the wrong message," unquote. Shortly thereafter, Vullo extracted legally binding consent orders from the NRA's 3 principal insurance providers, barring them from ever providing affinity insurance to the group ever again, no matter how lawfully they do so.
Apparently, Ms. Vullo's warnings were effective.
These actions worked as multiple financial institutions refused to do business with the NRA, citing Vullo's threats. This was not about enforcing insurance law or mere government speech. It was a campaign by the state's highest political officials to use their power to coerce a boycott of a political advocacy organization because they disagreed with its advocacy.
Sounds pretty bad for Ms. Vullo. Then again, we haven't heard the other side of the case yet. Before we look at the respondents' arguments, let's look at some of the questions the judges had for Mr. Cole. The NRA is claiming that their freedom of speech is being violated. Justice Thomas asked about that.
Mr. Cole, what is the speech here, protected speech, that you allege has been suppressed?
Promoting guns, advocating for gun rights, sending the wrong message. It is precisely the speech of the NRA which caused Vullo and Cuomo to decide to target their partners and seek to coerce them into boycotting the NRA. So they are seeking to penalize the NRA because of its speech advocating for gun rights.
So your argument is that the sanctions on a third party suppress the speech of NRA.
Yeah, it doesn't, Your Honor, the Court's First Amendment jurisprudence does not require proof of suppression. It requires proof of burden. If Vullo had imposed a $1 fine on the NRA for promoting guns, it would be unquestionably unconstitutional, even though it wouldn't actually suppress their speech.
That's an interesting approach. Do the actions of Ms. Vullo suppress speech, burden speech, or abridge the right of free speech? More on that and the applicability of the First Amendment later. Justice Jackson brought her understanding of the issue to light in one of her questions.
I mean, so that's why we have to be really careful about what you're alleging is the First Amendment problem, because the government can regulate conduct. Correct?
I agree. And if this was a case in which the government had said, the NRA is violating the law left and right, and we have to respond to that, and here are the legal obligations, that would be one thing. That is not what they said. They said, we want to shut the NRA down. We want to put the gun lobby out of business. What the title of the guidance letters that she issues are guidance regarding the NRA and other gun promotion organizations. The whole guidance is saying, I don't like the fact that people use guns. I don't like the fact that people advocate for the use of guns. We need to stop this. We need to stop this now.
So this doesn't appear to be a case of punishing the NRA for their illegal insurance program, but an attack on any and all gun promotion organizations. Justice Jackson brought up another question related to the freedom of speech issue.
So Justice Kavanaugh picked up on what I think might be a critical distinction, and I'm just trying to understand it. So he said, here we have a situation in which the government is not acting on a company that is itself in the business of speech, which is true, unlike Bantam Books, where it was.
Mr. Cole based his argument primarily on the case of Bantam Books, which is why Justice Jackson brought it up. Do advocacy companies still have free speech rights? From her comparison to the Bantam Books case, this seems to confuse Justice Jackson. I mean, after all, Bantam Books makes books, which to the twisted understanding of the court is speech rather than press. The NRA's business is advocacy. What is advocacy? The support of a policy or cause. Well, how does one advocate for said policy or cause without expressing such support either by voice, print, or digital publication? Now, Justice Kagan explored the question of reputational risk.
The idea of reputational risk, Mr. Cole, that is a real idea, right? It wasn't invented for the NRA. There is a view that bank regulators have that companies are supposed to look at their reputational risks.
Right.
So how do we know? I mean, there's obviously a lot about guns in that letter, but it might be that gun advocacy groups, gun companies do impose reputational risks of the kind that bank regulators are concerned about. So how do we know?
Now, this raised an immediate question for me. Where does any government get the authority to evaluate the risk to the reputation of an institution? Now, should a company be concerned about their reputation? I would think so generally, but on many more levels than what I've seen regulators consider. For example, Justice Kagan seems concerned that guns impose an unfavorable reputational risk to the company. On the other hand, I consider businesses that seek to infringe on my right to keep and bear arms to be not only an unfavorable reputation, but cause to avoid doing business with them.